Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, October 2nd, 2019. The time is 9:10 a.m. and we are meeting in the hearing board room in Diamond Bar. We have one change to our calendar today, and that is the matter of OC Waste and Recycling, case number 6151-1 for a regular variance is off calendar. That means we have one matter to hear today, and that is Union Pacific Railroad Company, case number 4979-3 for a short variance. And who is representing Union Pacific Railroad today?
Good morning, members of the board. My name is Sue Park with Morrison & Forster on behalf of Union Pacific Railroads.
Okay, thank you. And who is representing the executive officer today?
Teresa Barrera.
Okay, Ms. Park, have you been before us before? Are you familiar with our process?
I have not been here before.
I think you turned off your microphone. Just leave it on, it's okay.
I didn't realize I could just leave it on. I thought I had to press it down. So as evidenced by that, no, I have not been here before, but I have read the information to get an idea of what is to be expected at the hearing.
Okay, generally the way it works is we allow short openings, first from yourself and then from Ms. Barrera, and then we'll present any witnesses. Ms. Park, do you have any witnesses who will be testifying and presenting evidence today?
No, I do not have any witnesses here today.
That's an issue because I'm not sure how the hearing board can rule on a matter without any evidence before us.
Our understanding was that because the petition was submitted under oath and the petition included factual bases upon which we are asking for the variance, that would be sufficient. But if that will be an issue, we are happy to submit a declaration attesting to the underlying facts to help the board.
We may be able to do that if the executive officer of the district stipulates to that. However, our findings, while we do not have to follow the procedures, the evidence rules that courts need to follow, we can't accept hearsay. We cannot base any one of our findings completely on hearsay. And so we need to have evidence. And that's not to say that we have not proceeded on declarations in the past when there is stipulation by both parties as to the facts. And so I'll go to Ms. Barrera and ask for your comments in opening, well, not opening, because I haven't asked Ms. Park for opening, but your thoughts on how you wish to proceed as the districts and your position on that.
The district doesn't oppose the issuance of this variance, but recognizes that the absence of a witness today does present issues. And I suspect there may be some questions and some holes that the petition itself, although the petition itself is under oath, and so it is similar to a declaration. I just suspect there may be some holes in the evidence, and I had suggested to Ms. Park before, we started this morning that it may be that this matter needs to be continued to another, to tomorrow, or when she could get a witness or a declaration. If it's going to be a declaration, I would need some time to look at it, so maybe not tomorrow, but I think it is a fairly simple variance in some regards. And I think that the petition is very well written, and she has some proposed findings, and those pretty much mirror the petition. So I think that it's possible to do it. And again, I mean, we're talking about a 7-day variance with minimal emissions. I don't think that there are there's not much to be done in the way of conditions that could be added in order to accommodate this historical train. But I suspect there may be some questions that the board has. So I will leave it to you.
Thank you. I'm trying to find the rule, but yeah, we do need to base our, I do know that we need to base our findings on evidence. First, I'm going to say, look at, well, first let me ask you, Ms. Park, if we are to continue this to tomorrow, can you return with a witness?
Regarding a witness, I would have to check with the client to see whether there is anybody who is either local or is able to travel in terms of tomorrow. So I will probably need at least a recess to find out whether I could get a witness. In terms of a declaration, I expect that would not take as much time to prepare, and I would be able to help prepare that remotely. So that may be a more sure way to make sure that we could get something on file quickly, especially given that the expected date for which we're asking the variance is approaching rather quickly, starting October 9th.
Yes. Senator, yes?
I read the petition. It's, the evidence is, in my view, as to why they're requesting a variance, is included. It's a 150-year celebration, period.
Okay.
And,
That's not evidence, that is facts
fact.
stated and alleged in a petition, but evidence is of a different nature. We take evidence by sworn testimony, we take evidence by documents that are entered into evidence. The petitions are not considered evidence. So it's not sufficient that there are allegations, and we cannot ask questions, and we don't have any either sworn witnesses in front of us, or there hasn't been agreed upon declarations that have been stipulated to by both parties.
all I'm saying is the petition is a statement of facts, simply put.
Okay,
And it's, may I finish, please?
yes.
And it's for celebrating 150 years of the choo-choo train, which people benefit from. So I think what she's asking you to do is have somebody provide or submit an affidavit saying what, maybe that would become evidence. Is that correct?
Yes, I'm going to take conversation, but as the attorney member, I'm going to make this decision because I understand what evidence we need and how the rules work. But yes, Ms. Verdugo-Peralta, I would like not to have a deliberation on what we have read without having the evidence presented to us. But Ms. Verdugo-Peralta, if you had another type of discussion.
Thank you, Madam Chair. Ironically, I have a lot of relatives who have worked for UP, retired now, and so I know that there's a lot of people available throughout this basin that have the ability and the authority to come up and be here at the AQMD, and I was looking forward to listening to their testimony, but more importantly, this train is going through the basin, and the areas where the railroads are, people of color are next to those railroads. I was hoping that there would be some testimony from the public or comments from the public. While I recognize the fact that this is a commemorative celebration and tour of Big Boy, I still think there absolutely needs to be evidence and somebody that we can hear from UP and hopefully maybe the public. Thank you.
Okay, so what we'll do is we'll take a short recess, and we will allow, I'm sorry, Ms. Park, to, how long do you think you might need? And we'll take as long, and we could check back in 15 minutes. Would that be enough? And then if you still haven't, we'll decide from there. But a live testimony would be the best solution. However, if not, then a declaration would also suffice, but it would have to be a declaration that is reviewed by Ms. Pereira, and it would be similar to if we were on consent calendar, where we do rule on declarations, but they are stipulated facts and agreed upon by the district. So we'll go off the record until about 9:35, and at that time, we'll just check in again.
Great, thank you very much for the
Chair?
flexibility.
Yes, Senator, before we go.
I think the declaration should perhaps include the facts as stated, declaring that they are the facts. And the district may want to accept it or not. But I would say that it just has to be written, but you can't deviate from what's been put. The declaration cannot vary from that which has been included in the petition, I don't think.
Often they do, because things will change between when a petition is written and when evidence is given. However, if we do not receive evidence on which we can rely to make our 6 findings, we would have to vote no. So that's the importance of having evidence in the form of a witness.
Of course. we
Okay.
understand.
So we're in recess, and we'll be back at 9:35. We're off the record. Thank you.
Thank you.
We are back on the record. Ms. Park, do we have an answer as to whether we have a witness?
Unfortunately, I was not able to reach the person who signed the petition, as she would be the person who would have the best knowledge in terms of who could be the live witness to testify. I have also reached out to another attorney that I am working on this case with, who is a little more familiar with the client and who may have additional contacts. I have reached out by both desk phone, cell phone, and email, but have not heard back yet. A follow-up question would be, the person who signed the petition, her name is Erica Montefusco, and she is located in Omaha, Nebraska. If we are not able to find a live witness who is local, would the board consider accepting her testimony by telephone?
That's a good question. We have not done that in the past. I don't believe we've ever done that in the past. I think we would prefer to work out a way to come back with a declaration, but the declaration would have to, again, be reviewed by Ms. Barrera for the district. And also, I did hear that at least one other board member, and in addition to myself, have questions that are not answered by the petition. And so those questions would also have to be answered, which is where it becomes more difficult, because once questions are raised and answered, they often lead to additional questions. And it's only to the detriment of the railroad to not have those questions answered. Because if we cannot find evidence and make each one of the findings, there is a potential of voting no, because the case has not been made. So with that said, I would hope that you'd be able to. We do not need the witness who signed the petition. We do not need the person with the absolute best knowledge, although that is always of benefit. However, we understand that, as you just stated, that witness is out of state. A local witness with knowledge of what you're asking for and what the impacts would be sufficient. So I think at this time, one, we could wait and see what you can find for the next, however long, and see if we can. Okay, and per the clerk, we do not do telephone testimony. That's not a possibility for us.
Thank you for clarifying.
And the other is to work out a method by which a declaration could be done and reviewed. And Ms. Barrera wanted to be heard.
Yes, I was thinking that it might be, we could wait a short period to see if she could contact somebody, but it does not seem like somebody's going to be making it in here today. So perhaps the best course of action would be to continue the case until tomorrow. The railroad could try to, number one, prepare a declaration, and I guess I would encourage the board to put out the questions that they have so that those questions could be addressed by way of declaration, and that with the, as you've mentioned, that may not be sufficient, and that they should additionally try to get a witness in case it is not sufficient. But the best way to ensure it's as good as it can be is for all of you to ask the questions you may have.
That was what I was going to do if it came down to a declaration. Thank you for that. But as I cautioned you, Ms. Park, that may, in the end, not be sufficient. And so it's in your best interest to try and have a witness. But would you be able to be here tomorrow? Is that?
I can be here tomorrow. So what, if I may suggest, if we are able to proceed with both concurrently, while I could continue to try to find a live witness to produce tomorrow if the matter were continued until tomorrow, we could simultaneously work on a declaration in case no live witness is available. If the board is willing to, continue on both tracks simultaneously. I would also agree with the district that it would be very helpful to have some of those questions ahead of time so we could prepare a sufficient declaration as
Okay.
backup.
Okay, board members, let's proceed in that manner, and we will, Mr. Balagopalan.
I was just wondering, is Skype appropriate? Because, no?
No, we do not, we need either live witnesses or a declaration. Why don't we, at this time, board members, does anyone need a few minutes to gather any questions you might have that you'd like to have answered in declaration? Or are we ready to ask those questions?
I have no
Okay.
problem. Ready to go.
Okay, Ms. Verdugo Peralta, would you like to begin with questions you would have?
Thank you,
And
Madam.
also, and let me tell, Ms. Park, you can take these down. However, this proceeding is webcast. And you can go onto the AQMD.gov website, and this webcast will be available, and all of the questions will obviously be there for you to listen to.
Of course, thank you.
Thank you, Madam Chair. One of my main questions is, as this big boy is going down the track on its tour, is it going to stop at any locations? How many stops are there going to be? And is it going to be idling during these stops?
And what are the emissions consequences of that idling?
Correct. Thank you.
I'm writing them down, too.
Isn't all that spelled out in the petition?
It's not clearly, so Ms. Verdugo Peralta would like clarification. All board members need to be able to find substantial or significant evidence, persuasive evidence, in order to make their findings. Mr. Balagopalan.
Yeah, I was just going to ask for clarification, because Exhibit A shows the schedule when it's going to, but I think part of it shows when it's actually outside the district jurisdiction. So, at one point it comes into the district, and when it leaves the district, the clarification, because I think October 8th, which is listed in the table, does not appear to be in the district. So the clarification on that would be useful.
So clarification on the schedule and when precisely it will be in the district, when and where.
And when it would exit the district.
I had questions regarding that seemed inconsistent, and perhaps it's just I'm not understanding. And so if there could be clarification, please. In several places, but I'll just begin on page 3 of the petition, in number 7, which begins in paragraph 2, where it's discussed what percentage opacity is to be expected. The first sentence states opacity will likely be under 20%, except during the initial firing. But then it goes on to say when several minutes of up to 60% opacity could occur. But then the only other discussion of opacity is while traveling downhill and on relatively flat terrain most of the route, the locomotive smoke will likely be under 40%, which is obviously higher than 20%. So I'm not sure where the 20% number came from. Then the next sentence says traveling uphill, opacity will likely be between 60 and 80%. So again, I don't know how that ties to 20%. Except during the firing of the engine. Similarly, on the last page of the petition, not the last page, sorry, it was page 8 of the petition, under the excess emissions, it says excess opacity 40% with very short-term sand-related amounts at 100%. So I'm left to wonder, what is the opacity? For how long will that opacity be greater than what percentage? That has to be very specific, and I think it's related also to some of the questions that were asked by Ms. Verdugo Peralta and Mr. Balagopalan. What's the schedule? How long will it be in the district? When will it be out of the district? Will it be idling? What's the opacity when idling? And how long will it be traveling? So that we can make that decision and weigh. The other, well, the second issue I have is, can there be a clarification that you're not seeking, I mean, we can't give it, variance from Rule 402 for nuisance. Nuisance is a rule we cannot grant a variance from. So I understand that someone may have had a discussion with the clerk's office after filing. But just to be clear that that's no longer a request. Also, I wanted to just have a clarification as to Rule 401 and Rule 405. What subsections are you requesting? It looked like 401B1, but I don't know. And is it the entire Rule 405, or is it a subsection thereof? And my final question, we need to make all of the 6 findings. And one of the 6 findings is there is an arbitrary or unreasonable taking of property or the practical closing and elimination of a lawful business, but under what is the harm, or however it's asked in the petition. Let me find that section. Oh, here it is. Okay. This is on page 6 of the petition, number 17. What would the harm to your business be? What would be the harm to your business during and or after the period of variance if the variance were not granted? And the answers were not applicable. So if you can describe for the board so that we can make a finding, and then also weigh, then we would have something to weigh the emissions impact against any potential harm. So if you can have a witness explain in a declaration, what is the impact to the railroad if a variance were not granted as requested? Those are my questions. Anyone else have any other further questions that are not clear from the petition that you'd like to see in a declaration? Dr. Bernstein.
No, Madam Chair, my questions had to do with what rule subsections were involved, and also trying to figure out what the harm was as well. So just for clarification, to make the appropriate findings for the variant, to grant the variance, that's ones that I had. Thank you.
Mr. Balagopalan.
I think I was also going to add, I think there are rail fines. I don't know if their tickets been sold, and if there's harm to the folks who bought the tickets, and what the economic impact would be.
True, that would be part of it. Thank you. Anything else? Because we may have declaration and we may not have a live witness. Senator, did you have?
I have no question. Some of the statements or inquiries that have been raised, they are answered in Exhibit A. The schedule, the time, the location.
I also, I thank you for raising that, because I'd like to also request that information be made either bigger, larger, so it's readable, and also if it could be possibly explained. I know there's some explanation on page 16 in words in Exhibit B, that it will be in the South Coast Basin for 8 days, 8th day through the 15th, for a total of about 78.5 hours. If that could just be perhaps clarified and just made bigger. Even that chart on that page is a little too small.
On Exhibit, on page 13 and 14, it talks about scheduled events, the time layover and all that, the dates that it will be in motion and moving, dates that it will not be. So it's pretty clear.
I think except some of those dates they have indicated, they're not in the district jurisdiction.
They're not in the district, I understand.
Yeah, so I think they may have to adjust Table B, Exhibit B, and maybe even update because in Table B, they say total operating time basin, 78.5 hours over 8 days. So I think they've included the time and they're not in the district. I didn't really add it up, but maybe a correction if the time they're not in the basin.
I mean, it's all included in and out of the district. What you need to do, I think, the question should be answered, at what period of time will the training be in the districts? And for, what would be its operation at that time? Would it be stationary at a station, or will it be traveling through the district?
And what opacity levels? Ms. Verdugo,
And
Peralta.
also, I don't see an estimate of what the emissions would be at those points. I recognize, for instance, San Bernardino, Colton, that are within our district are going to be the main locations in our district, but I really would like to know, and Beaumont, I really would like to know what the estimated emissions are going to be at those locations.
I'm seeing, if you look on page 16, the Exhibit B, just, I know it's very small, but if board members can see if there's additional information that might be needed. That chart is total operating time in basin is about 78.5 hours over 8 days. It also goes on to break it down by date, route or location, duration in hours, opacity levels, and then the percentage of time at those opacity levels. That seems to me to, unless there's a change in it, that seems to be pretty comprehensive. Is there anything in there, or maybe it's just not legible, it needs to be bigger?
I believe in the petition, they indicated when they do sanding, how many pounds per hour they expect to emit during that period. Of course, it's not clear how often they will do the sanding. I think it's once per hour, somewhere I think I read, and whether it can be minimized when it's in the, in the residential areas where there's a lot of the communities that may be impacted by the sanding.
And so the question you have is, that raises a question for me. I'm not sure that there was a quantification of Rule 405 with regard to the sanding and the weight of the particulate matter, I believe, is that rule?
I think on page 6, second paragraph, they talked about it. Almost the very last.
Did they quantify?
They did. They say they will be equal to about 1 pound per hour, along with some amount of carbon soot, and then it's therefore exceed the allowable limits in 405 of the 0.99 pounds per hour.
Okay, so if I guess the clarification would be, I think that under excess emissions, didn't it say not applicable?
Well, I think the two, there's opacity
C
emissions,
attached, C
and then
attached.
there's the
Okay.
PM emissions, so that, yeah.
Okay.
And it's the PM that I am most concerned about.
Okay, so I think what you're hearing is it would have been helpful if there was a witness and we hear the case, then it would be explained at one time very clearly what the excess emissions are, and we wouldn't have to parse it out or find it. So if there's just an easy way through a declaration, hopefully through a live witness, that could be explained. I think you see some confusion. Senator.
Yeah, I think they were asking how you quantify the emission levels. They went from coal to diesel and sand combined, and it's not defined technically as a method of reducing emission. Explain to us why this is supposed to be state-of-the-art method for reducing emission, and emission levels that they're suggesting can be quantified.
Well, and I think that's a different point. I think actually that's one of the findings we need to make, is that emissions are reduced to the maximum extent feasible. And if that can be explained, but I think that that's stated in the petition, but is it state of the art? But The quantification of excess emissions would be whatever is over what is allowable by a rule. So for opacity, it's whatever percentage opacity, and for the solid particulate matter, it's by weight above what the limit is in 405.
I think the one, probably the challenge also is I'm not sure how the Union Pacific is going to do this in determining the opacity, because it's difficult if it's a moving train or if it's idling, and who's going to be reading it, and how they're going to determine when it exceeded the limits and how many times during the time it traveled in the basin it exceeded the opacity limits. I'm not sure how you're going to read the opacity is, it's aggregate of in an hour, exceeding in 3 minutes in an hour. So that's going to be a challenge unless there's there's a default assumption or something, that's made that we could use as an alternative.
And I think that raises another issue, which I assume that the conditions that were discussed before we began today, or when we began today, will probably address monitoring in some way, but I don't know. But generally, we need a witness who speaks for the railroad or the petitioner to state in testimony or in a declaration that they understand the conditions and they agree to abide by them, and that is feasible. So we'll need that as well. Anything else? As you can
Yeah, I
see,
mean-
it gets more and more. That's why it's great to have a witness. Senator.
Yeah, using sand, I understand, to reduce emission, and you can say that's the state of the art, that's the best effort. I'd like to know how they came about selecting sand to be combined at the exhaust to reduce the emission. Give me some rationale for that method that was used.
I believe the sanding is done to clean the deposits
Clean it
on
out.
the pipes and the tubes.
I believe the sanding is not used to reduce emissions. In fact, as I read it, it's what causes the 100% opacity for the 15 to 30 seconds per hour. But we should be clear, I guess.
Sand was designed to reduce the smoke, the soot.
Right.
I fear we're getting into deliberations over something we haven't even heard, but Ms. Verdugo Peralta, yes.
Thank you, Madam Chair. In looking at, on page 16 of the excess emissions, when it says sanding en route, for instance, the second one, Yermo to Colton. Okay, I don't know where that is going to be done, and Yermo is obviously not in our district. Colton is, so is it going to be done closer to Colton, closer to Yermo, halfway? It's kind of very vague, and I know that it's probably at the discretion of the engineer. However, I would like to have some type of an idea on that.
We have a different emission, whether it's incline, flat surface area, and going at that distance between one and the other. Is it flat or is it inclined? And I think that can tell you whether or not you have less emission or more.
Well, that's why emissions are to be determined, but to the extent that a witness can explain in more detail, the board would like to hear it. Anything else? Okay. All right, so Ms. Park, we will adjourn. We do have another hearing tomorrow. But we will have time to take up this matter as well. And so hopefully we'll have a witness tomorrow. If not, there's a lot of work to be done on a declaration before tomorrow. Well, we could take this matter up second, but I don't know how long the first matter will take.
As stated previously, I will work on getting a live witness produced for tomorrow, but in case I am not able to do that, I will also work on the declaration to address some of the questions, all of the questions that were raised by the board today.
Great, and to the extent you can be in contact with Ms. Barrera, that will probably help the process along to show any declarations you might have and what you plan to testify to in those declarations.
Yes, of course.
Okay,
If there's a declaration, if it's signed by the person who did the petition, can we also have that, is it appropriate to have that person maybe on Skype or something, so we can ask questions?
we are not having Skype or,
not having
no,
Skype.
so
Okay.
let's not. That's the same thing as having a witness testify on Skype. Okay, so if nothing else on this, we will continue this matter to tomorrow, October 3rd, and we'll take it up at that time, in whatever form it appears. Thank you.
Thank you.
Okay, board members, I have one other matter of business to report on. It's not for discussion, because this is a matter that is still live. But for your information, the hearing board was named as a defendant in a matter that we heard last week. The court in that matter was asked to enjoin the district from enforcing a rule against that petitioner. We did engage our outside counsel that represents the board. We engaged that outside counsel to represent us since we were named as defendants as a hearing board. The hearing was yesterday, and the plaintiff did not prevail. So just to let you know that that did occur. Also, to let you know that it did occur, to remind all board members that we are administrative law judges. We do not engage in questions from the press or ex parte communications with anyone on matters. We shouldn't, even if they're done, engage with the press. But in this particular case, it is still an active matter that will be coming before the board again in November. And so, just a reminder not to speak to
Which case are we talking about?
Howard Industries.
I guess.
Yeah, well, that's what we heard last week. Okay, so I wanted to make sure everybody was aware of that. Is there any other business, board members, before we adjourn? Seeing none, we are adjourned.